Okay, good morning everybody, and welcome to the First Distribution SPLA update on PoPI. My name's Kevin Durman. I'm the GM for the Cloud and Hosting businesses at First Distribution, and I just want to make sure that audio is coming through clearly, so if you can, please just pop a message through in the chat window. That will be great, just to indicate that you can hear me, anybody. Great, thank you for that. Okay, so with that we can continue. So firstly, I'd just like to introduce our speaker today and say welcome to Theo Watson. Theo is the Microsoft attorney for corporate and legal affairs, and he's also become somewhat of a cloud specialist at Microsoft in terms of the legal implications of cloud and ensuring that Microsoft and the partners are keeping in line with everything that's going on there with regards to regulations. With me as well, I just want to do a quick introduction, although he won't be speaking today, is Chris Richardson. And Chris has joined First Distribution as the hosting program manager, and he joins us with a wealth of knowledge from the Microsoft side, but also having been in the hosting community as well. So welcome, Chris, and we look forward to Chris's input in further webinars down the line. So today we're going to be discussing PoPI, and initially this call also had the SPLA update. I just wanted to note to everybody that we've moved the SPLA update portion to the 9th of May, just to ensure that we've got some additional information that we will be sharing with you there as well on that day. So we will do the pricing updates on the 9th of May, and there is some good news for that pricing update. So the usual, whenever we say pricing update, it normally means increases. The good news from that is it will be a decrease. Just have an echo on the line. I just want to try and fix. Okay, that's sorted. Right, so moving along. If there is anybody on the call who has not dealt with First Distribution, I thought it would just be pertinent just to explain that First Distribution is a distributor, obviously, but we're a very focused distributor around the areas of data center, around virtualization, hosted applications, etc. So we are focused in this particular area. We cover a lot of products in different stacks, so from client computing, hosted solutions, which we are speaking about today, but all the way through security software, virtualization, storage servers, and networking. So that's just a reminder to everybody of the full stack of what we do as a business. So let's start off with the PoPI discussion. And before we go right into it, what I'm keen to do is just a bit of a poll, just to get an understanding of where people are at this. So the first thing that I want to do is just to ask some questions. And the first question I'd like to ask is, does PoPI prevent or facilitate the, I just want to get the full question up here, hold on one second, the transfer of data outside the borders of South Africa? And you'll see that on your screen there, and if you can please click one of the voting numbers there of whether you feel that it prevents or facilitates the transfer of data outside the country. Okay? Okay, so I'm going to close off the voting, and I'll share these details with you of what people are feeling. So we have got over here that 23% of the people on the call feel that it prevents, and 77% feel that it facilitates the transfer of data out of the country. The second question I want to ask is, under PoPI, who is responsible for establishing the security standards within the IT environment? Is it a responsible party or customer, or is it the operator, or cloud provider, or the hoster? So here's that question, and you can vote. I assure you this is anonymous voting, so don't feel scared to vote. And as all multiple choice questions, it's always recommended to just go with your gut feel. Okay, so I'm going to close off the voting in a moment. We have got 35% of people saying it's a responsible party or customer that's responsible, and 65% saying that it's the operator or cloud provider or hoster. And you'll see those results coming up in a moment. Okay, there's the results. Okay, and then the last question that I've got over here is a cloud provider obliged to enter into a written agreement with a customer or responsible party? So is a cloud provider obliged to enter into a written agreement with a customer or responsible party? Okay, I'm about to close the voting off on that. So last chance to cast a vote, and we're closing it off, and I'll share the data with you here. So we have got 78% of people saying yes, they are obliged to enter into a written agreement, and 22% saying no. So in a moment, I'm going to hand over, but not just yet, to Theo, who's going to be able to shed the light on these questions, and hopefully when it gets to the next section towards the end of the presentation, you'll actually have clarity on those questions and have those answers. I've explained that we're doing the SPLA update on the 10th of May.
So we have got 78% of people saying yes, they are obliged.
Just do have an echo. I just want to make sure everybody is on mute.
And 20% saying no. So in a moment, I'm going to hand over, not just I'm going to be able to get light on these questions, and hopefully when...
Okay, we're just dealing with this echo that's on the line at the moment. There we go. I think we have killed it.
The section towards the end of the presentation, you'll actually have clarity on those questions.
Okay, sorry about that. Right, moving along. So I wanted to lead into this with a brief discussion about a common belief fallacy. And a common belief fallacy is something that's very typical in society, and it's something that we're all familiar with. Ancient common belief fallacies believed that the world was flat, and you were really challenged in your environment if you had any other perception at that particular time and you said, no, the world is round. Or another common belief fallacy was that the world rested on the back of a giant tortoise. So those are the examples of common belief fallacies. So some of these common belief fallacies that we find in the cloud are ones that I'm sure you would have heard before. Things like the cloud is not reliable, the cloud is not secure, the cloud is the answer, what was the question? That's a more positive one. Typical ones is I can't move my data overseas. Legislation prevents me from doing so, and so I can't do that. I can't store personal information in the cloud. Is another one. And the environment that we're in is fraught with these types of thinking. Some of them may be right, some of them may be wrong, and we'll get the clarity of the situation in a moment. And I want to link this through to how easy these aspects of a common belief fallacy are actually able to infiltrate their way into society. And that leads me to a question, and here it's a hypothetical question, unless you feel like typing it in, when I say, what is the most dangerous thing in South Korea? And when I've given this talk before, and to an audience that will tell me things like, no, it's a snake, no, it's a bear, it's a criminal element or something like that. But the actual most dangerous thing in South Korea, if you had to ask a person who lives there, is the common fan. And I'm sure if I could hear you all, there would be gasps of disbelief, but I promise you this is entirely true. The common fan is known as one of the most dangerous things. And anybody who lives in South Korea will tell you that you cannot sleep in a room for a period for longer than 2 hours with a fan on in the room. It leads to sure death. And so nobody will do this. And the way it leads to sure death is it sucks the oxygen out of the air in the room. So how this came about was there was a student who was living in South Korea. Her name was Sarah Edwards, and she was a teacher from America. She went across there, and one of her colleagues from the university came to pick her up one night, and as they were leaving her flat, where she had a bunny in the flat, the friend said, "How can you leave the flat with this fan on and your bunny?" And she said, I don't understand. What's the problem? They said, "Well, you will come back to a dead bunny. That is one thing for sure." And she said, "I don't understand." And they said, "Well, you've got the fan running. It's surely going to take all of the oxygen out of the air, and it will create this problem." And she then found out that this is a common belief where everybody in South Korea believes that you cannot have a fan running. It is such an issue that there are warnings on the appliances. And the warning says, "Danger, lethal appliance." You should be seeing this on your screen any moment. So, warning, danger, lethal appliance, do not point at face while sleeping, must open all windows, and note, not it may cause death, but will cause death. So they are extremely, extremely serious about this warning, and there's, in case you didn't understand, it's even in English as well, it says open the window and set the timer for no more than 2 hours. So this is a fantastic example of common belief. Now, you will be sitting in this conference on this audio webinar and saying, well, you would never fall for something like that. Common belief, not me. These people are obviously not thinking straight. Well, let me ask you this question. How many people out there on this call bought one of these? And I'm not only going to ask you this question in a hypothetical way, I'm actually going to do a poll on that, and I'm going to ask you to vote. And here again, I tell you that the poll is completely anonymous, so please feel free. So did you own a power band bracelet? Or do you still own a power band bracelet? So the poll's open there, and if you can please vote. Okay, so we've got 89% saying no and 11% saying yes on whether they owned a power bracelet. So I have a feeling there that firstly what I noticed on this particular one is that the amount of people that voted went down. So I do think that we have some people who are saying, okay, well, I'm not going to vote in this particular poll. But do not feel embarrassed if you bought one of these. It's completely understandable because the power band bracelet showed great benefits. And this was up to a 500% increase in strength, in power, and in flexibility. And I don't know about you or those 89% who never bought one, but certainly with those kind of claims, it's worth a shot and it's worth getting one. Now, the power band balance bracelets were doing fantastically, and they claimed to have this fantastic increase on that. But however, in January of 2011, they were taken to court by Australian consumers, and they had to admit that the power balance brands are absolutely worthless. There were independent studies that were done, and they showed against placebos that there is absolutely no difference in the amount of strength and power or in flexibility. And what happened was the company that produced these was liable for $66 million worth of claims against them for these power band bracelets. Their amount of sales that they had for that year ending equates to about $35 million. So it was amazing the amount of sales that they had. However, the claims against them were far outweigh that. So what they did was they filed for liquidation, and you would think they went out of business. However, they did not go out of business. They landed up selling the company, and even today, you can go online and you can buy a power balance bracelet. In fact, they have been redesigned, streamlined, and they are now perforated. And this is the next level, probably the next level of scam. But as you can see, they've got a money-back guarantee, a 30-day money-back guarantee as well, and they still have athletic endorsements and all these different types, etc. So when you think about this and you think of the levels of that the common belief fallacy extends to, we really need to question all of our thinking. And when it comes to the area of cloud especially, we need to worry about what our customers are telling us they need to do, what we think is the truth, and what is the truth, and what do we really need to focus on out there. So with that, I'm going to hand over to Theo Watson, who's going to take us through the presentation on PoPI and take it from there. And I hope at the end of the presentation we have clarity. Reminder, we will take questions at the end.
Right. Good morning, everybody. First of all, thank you very much to Kevin and to First Distribution for putting together this webinar. I certainly hope that it's going to be informative. It has certainly been interesting so far, particularly as far as the voting is concerned and common belief fallacies. Believe it or not, Kevin and I have a great theme around that, and if you ever have the opportunity, you've got to ask him about Bruce Lee playing ping pong one day. Anyway, moving on. Here we have PoPI, the legal and regulatory position in South Africa, and from an agenda item sort of view and flow as to how we're going to move. The idea is that I'm going to give you a very quick update around where we are on PoPI. I'm then going to take you through some important definitions so that you understand the sort of basic players within the PoPI environment. We're going to do a little dive into data sovereignty and what PoPI says as regards that. Then we're going to look into the responsible party obligations, and lastly some of the hosting considerations, basically pulling together the first four topics into the final regarding the hosting considerations. So, moving on. Where are we as far as PoPI is concerned? The reality is that PoPI has been something of a Jurassic Park endeavor. It's been close on 15 years odd in the making, and we are very, very fortunate that as of late last year, beginning of November, PoPI was effectively signed into law by the President. However, sadly, it still sits in limbo, because it has not been given an effective date. So while we have a piece of legislation that has a number and is enacted, it is not effective until the President fully and finally declares an effective date. Just for your technical information, as of 2 weeks ago, Chapter 5 of PoPI was enacted and was given an effective date. Now, that doesn't mean that we have to have a panic, and there is certainly no cause for panic, because Chapter 5 is really just the establishment of the information regulator within PoPI. So what it does tell us is that the President is certainly keeping his eye on this piece of legislation. It is not stopping, it is certainly moving forward, and the fact that the chapter around the establishment of the information regulator having been given an effective date as of 2 weeks ago means that this is a serious piece of legislation which is very likely to sort of come into its own probably within the next 6 to 12 months. The practical holdback in all of it is that the establishment of the Office of the Information Regulator is certainly going to take some money and some time to structure and establish. So quite literally, all that we are waiting for at this point is the establishment, the formal establishment of the administrative body that will be the information regulator before PoPI is given an effective date, and the estimation, as I said, is somewhere between 6 to 12 months from today. Right, moving on. Some important definitions on the PoPI. Just some context for this. The reality is that, as with any piece of legal document, it's complicated, it's long-winded, it's difficult to read. I'm hoping that by running through this, what I'm going to bring to the surface is really just the essential players and the essential elements of what PoPI is all about. So at least to arm yourselves with a little bit of the basic information so that you've got a sense of what PoPI is all about. All too often legislation, which is intended to have practical consequences and underlying intentions, gets lost in legalese. So I'm hoping that this particular section of the deck will inform you as to the very basics of the players and the intentions behind PoPI. So starting with a data subject. The data subject is at the core and heart of PoPI. That is essentially you and me. So PoPI is designed, and ultimately this is the core intention of PoPI, is to protect the personal information relating to a data subject. So this is all the valuable information that belongs to you and me as individuals. Following data subject, you'll see there's a definition of person, and this is a slight variant from what we find around the world, but a person also includes a juristic entity. So that is a company, a close corporation, a trust, something that is not a natural person, not a living person such as yourself or me. This is, as I said, a slight variant from what we're seeing in legislation, particularly in Europe, where essentially you have the right to privacy only insofar as you are a natural living person. The next definition that we're going to look at is that of an operator, and an operator is essentially what we're dealing with around the table, a first distribution, a Microsoft. Any person that is supplying a cloud service is by definition going to be an operator. An operator invariably works for or provides a service to what we have referred to as a responsible party. This is ultimately going to be the customer who receives the cloud service, be it a bank, be it a telco. That is the, and I like the definition and I like the use of the word a responsible party, simply because it encapsulates exactly what PoPI desires, which is that this particular entity is responsible for the processing and responsible processing of a person's private information, their personal information. And then lastly, further following on sort of the heart of what this is about, is the definition of personal information. And while there's a very, very simple definition around it, the reality is that it is a deep and a wide definition. So personal information is literally anything that can identify you or I. Now that could be my location, that could be my IP address, it could be my email address, it could be my ID number, it could literally be anything, even a combination of pieces of information that identify who I am. And when you start going into it, the reality is whether it is my gender, my religious or political views, whether it is my location, or even an anonymous type email address, when you connect all of these things, they start giving identity to who I am. And it is these pieces of valuable pieces of information that PoPI is designed to essentially be protecting. And it places all of that responsibility for the protection on the responsible party. So when we come into how do we apply all of this within this sort of SPLAR hosting environment? I think some of you will be familiar with this particular slide. Now, it's a complicated slide for even me as an attorney, so I've tried to make it a little bit less complicated by moving it into the next slide. And this is how we look at, essentially, how we believe PoPI is going to impact this particular engagement and environment. We'll start right at the top with someone like a Microsoft. So Microsoft is going to put out a particular cloud service, and by putting out that cloud service, it puts it out through a number of channels. One of them is the SPLAR, or the hosting environment, which is then passed on to distributors, which is passed on to customers and end customers. And we need to understand within that particular environment, if you are a hoster, where you fall and what your obligations are going to be under PoPI. Now you'll see that I've made a couple of small titles: subcontractor, operator, and responsible party. The reality is that this is sort of a best guess at this time. So until such time as PoPI is formally enacted and we start getting interpretations and we start having an information regulator that tells us precisely who is doing what and how it's all going to work, this is my best guess at what, from a definitions perspective, we are likely to see within the PoPI environment. Most importantly is to understand where you would fit in. Because if you don't fit into this and you don't understand what your definition is within this particular diagram, you're going to potentially get it all wrong as far as PoPI is concerned. Mostly, and this is where it starts becoming a little bit easier for hosters, is that it is highly likely that the end customer, be that the telco, the bank, the finance house, whatever it might be, is going to be the responsible party, not the operator. It is highly likely that the first contract that is entered into under that engagement as far as cloud service is concerned will belong to and be the responsibility of the operator. Now, why this is important, and we'll get into that a little bit later, is that again, as responsible party, as the name suggests, the responsibility for 99.9% of what is held within PoPI is going to fall within the realm and on the shoulders of the responsible party, not you as the hoster, not you as the cloud service provider. So, with that in mind, we're going to start drilling down into some of the detail around responsible party and what they've got to do, as well as data sovereignty. So, when we see this slide, the first thing that we see is, do we think that we can take data outside the shores of South Africa? We had done the poll, and I hope that we can redo the poll at the end of the session, and we can get slightly different answers. But the reality is that insofar as it comes to being able to take data offshore, the answer is yes, you can. And why can we do that? Because Section 72 of PoPI presents the framework that facilitates the how we do that. So in summary, Section 72 of PoPI basically says that provided there's adequate legal protection, or whether there's a performance of a contract, or if there's consent, or if it's for the benefit of the data subject, there's no problem with taking data offshore. In detail, I've set out what Section 72 requires. And I just want to pause and have a very, very quick look at the first block, which deals with adequate protection. Bear in mind that each one of these blocks is an alternative. In other words, PoPI does not require all 5 of these blocks to be ticked in order to take data offshore. It simply requires one of these blocks to be ticked. And the one that is most likely going to be ticked is the one around adequate protection. Remember, PoPI is essentially establishing a framework that allows commerce to take place in a manner which reasonably and responsibly looks after and protects a data subject's personal information. PoPI is not designed to stop commerce. It's not designed to stop business. It is designed to create a framework to protect personal information. And the transfer of data offshore is a risky transaction and engagement. But the reality is, if you follow any one of these 5 blocks and tick one of these boxes, you will comply with PoPI. So I wanted to stop and pause and just look at what adequate protection means. Essentially, it is the safe harbor kind of concept. And what the legislators had in mind was that when data leaves South Africa, if it is going to be processed in a country or by a company that is protected by law, that is essentially equal to what we got in South Africa, then the adequate protection measure has been achieved. So using the example that we use often enough within the Microsoft environment is that we've got data centers that reside in Holland and we have data centers that reside in Ireland. If data is leaving South Africa and ending up in any one of those data centers, the question is whether or not there is adequate protection from a legal perspective in the jurisdiction in which the data then resides. And I think we will all agree, while we may not be experts as far as EU privacy law is concerned, the EU certainly is setting the benchmark as far as standard for security and privacy is concerned. With that in mind, it's highly likely that provided information ends up in a data center in Ireland or in Holland, that you are going to achieve the adequate protection necessary under Section 72 of PoPI, and that in that instance there will be absolutely no problem with taking data offshore. Of course, you can also get direct consent from the data subject, or if you can't get consent and you're not sure if there's going to be sufficient protection, or you don't even know where the data is going, if it's going to be for the benefit of the data subject, or if it's at the request of the data subject, then surely there shouldn't be a problem in data going outside the borders of South Africa. Moving on, what I wanted to do is pause very, very quickly on this particular slide and just highlight to any person that is a responsible party that they've got a fairly onerous set of obligations to comply with when it comes to processing the personal information of a data subject. I've set all of those out there. There are 8 conditions, and each one of these goes into a fair amount of detail within Chapter 2 of PoPI. The idea here is not to sort of drill down into any of these in particular detail, save for the one around security safeguards, particularly because security safeguards is something that is within the realm of the operator or hoster. So if you're a hoster or if you're an operator of some sorts, security safeguards is going to be one of the most important areas within which you are going to have an understanding and with which you're going to have to comply. As an operator or a hoster, very, very few of these particular conditions are going to be specific to you. They are specific to the responsible party. It is the responsible party that is going to have to be accountable. It is the responsible party that is going to have to ensure that there is a specific purpose for which there is a collection or processing of personal information, not you as the hoster or as operator. However, when it comes to the condition around security safeguards, it is going to be a very, very important area that you as the hoster need to understand. And we're going to drill down into those particular sections now to make sure that you have a better understanding of basically what your obligations as a hoster or as an operator are going to be in that space. So when it comes to security safeguards, there are essentially 3 parts of PoPI that you need to know: Section 19, Section 20, and Section 21. Now remember, again, these are all ultimately the responsible party's obligations, but they have a deep impact insofar as a hoster or an operator are concerned. So when we look at Section 19, so far as security is concerned, it is the responsibility of the responsible party to take the reasonable and technical and organizational measures to protect its IT environment. What that essentially means that it is going to be, and I use again the example of a bank, it is going to be the bank's responsibility to structure itself in such a way that it makes sure that it has reasonable technical and organizational measures that protect the data subject's personal information. By way of an example, I could say the following. Imagine that there are bankers that are walking around with your personal information on their mobile device. It will be the bank's responsibility to say, we need to ensure that any mobile device has a security passcode, that it is encrypted, that it might have an in-tune system that allows for a remote wipe that is set up to ensure that it controls and protects personal information. Now, let me emphasize again, this is an obligation of the responsible party, not of you as the operator or as the hoster. It is going to further be the responsible party, the bank in this instance, obligation to make sure that when it comes to the operational side, not just the technical side, that it creates policies, that it drives training to ensure that despite all the technical stuff that it might have in place, that it teaches its people to be respectful of privacy and the protection of personal information. So by way of example, any one of the bank's employees could be sitting with a device. The device might even have a BitLocker and be encrypted. But it doesn't help us where that particular person doesn't follow the policy around locking their screen or closing their laptop lid. So it will then be the bank's responsibility to ensure that it creates a policy that enforces this particular behavior and that it delivers training to highlight to its employees at the end of the day that despite the device being encrypted, there is an obligation within that environment on the employee to close its lid or to make sure that it locks its screen, etc. And again, all of this is going to be the obligation of the responsible party. However, when you start moving away from Section 19 and we start moving on to Section 20, this is the first time that we start seeing a hoster or an operator's obligations under PoPI coming to the fore. And essentially what Section 20 says is that you as a hoster or you as an operator can only process information with the knowledge or the authorization of the responsible party, and even when you're doing it, you are going to have to treat that information as confidential. So here is a clear, and one of the very, very few sections within PoPI where there is a clear obligation on an operator stroke hoster to behave in a particular way. So the takeaway right now at this point in time is that the responsible party bears the hugest amount of obligations under PoPI. You as the operator have got a very, very narrow field of obligation and responsibility. In particular, when it comes to security, that under Section 20 defines and clearly describes that you can only process information where it is with the knowledge or the authorization of the responsible party, and notwithstanding anything else, you are obliged to treat all that personal information with absolute confidentiality. So, moving on, how do we close the loop knowing that data is flowing from a responsible party, for example, a customer, a bank type customer, and it's coming to your environment as a hoster? How do we control all of that? Section 21 closes the loop and requires that there be a written contract between the responsible party and the operator. And it doesn't require that the contract simply be any type of written contract. It has to be a contract which ensures that you as the operator are complying with what has been set out under Section 19. In other words, we go back to the operational and technical environment that the customer bank, for example, is creating, and the contract that that bank then has to enter into with you has to sufficiently state that you as the operator have to meet those security levels. So, how do we look at this from an example perspective? The example would be along the lines of the bank has a particular policy around encryption. So when data is at rest or data is in transit, it requires a certain degree of encryption. When you provide the particular type of cloud service that you are to that bank, the question is, do you meet that particular level of security, that particular level of encryption? Ultimately, there will be a contract. There now has to be a contract between you and the bank which establishes that you are obliged to understand and then maintain, meet or exceed the security measures that the particular customer, be it a bank in this example, has set out within its environment. And that, in essence and in a nutshell, sets out the kind of engagement that you as a host or as an operator are going to have to be focused on when it comes to engaging with a responsible party. Now, while I normally try and keep the conversation neutral from a technology perspective or from a particular provider perspective, I am obliged to point out that from a Microsoft perspective, we as a company have gone to great lengths to ensure that we provide in the back end and via contractual undertakings the best in industry provisions around privacy and security. Particularly when it comes to our enterprise agreement, which is perhaps not the focus of this discussion, but an indirect benefit, Microsoft has established firm contractual commitments that meet the standards that are required to ensure that customers at the end of the day receive the highest privacy and security standards. We make the contractual commitments in that space, and we provide the back-end service as far as that's concerned. More specifically, 2 weeks ago, just from an interest perspective, all 8 data protection agencies, 28 data protection agencies within the EU, endorsed Microsoft's enterprise agreement insofar as it achieves precisely the best security and meets the kind of privacy standards set by the European Union. Now again, when we're talking in the hosting environment, this is not something that is directly of benefit and perhaps not even directly of interest. But the reality is, bearing in mind that you are in the hosting space, you are providing a service that ultimately stems from and originates within a Microsoft center. Those back-end services that you are reselling, that you are hosting, are all going to be at the level and the standard that have been endorsed by the European Union's data protection agencies. So while again not a direct benefit, the indirect benefit is that the best in industry that Microsoft has received endorsement for, you will ultimately be reselling or hosting. So with that in mind, the final slide comes to, what do we have to consider under PoPI as hosters? And the reality is that which I have set out in the previous slides all fall together to be what you as a hoster or an operator need to understand. So right at the top there are the PoPI provisions that apply, and ultimately you need to understand which sections of PoPI apply to you as an operator or as a hoster. I hope that I've sort of clearly set out that we're looking at the security provisions within sections 19, 20, and 21 that will apply to you. I hope that we've understood that when it comes to who is important in all of this, it is ultimately the data subject. You and me as the guy walking in the street who's being protected by PoPI. And that when it comes to who has the responsibility for protecting all of that, it is the responsible party, ultimately your customer. And your customer is obliged to enter into a contract with you under section 19, 20, and 21 that establishes the security environment, be they technical and or operational measures that the responsible party has to put in place and that you have to commit to ensure that you maintain when you provide your cloud service that self-same level and standards security that the customer has put in place. And essentially these all hang together and keep on moving together in a dynamic fashion. You need to understand that if there is some kind of security change within your customer's environment, you're going to have to be aware of that, analyze that, and determine whether or not you are still, in providing the particular cloud service, complying with that new standard. So these things are going to be dynamic, they're going to be interactive, and you're going to have to be in tune and alive and aware to them as they move on. That is at the last time I looked pretty much all I had to say on this matter. I certainly hope it's been informative. I hope that the message has come across, and sort of we open it up to questions at this time.
So we have 2 questions at the moment, so please feel free to type in any of the questions that you have. The one question we have, Theo, related to the data sovereignty issue. And that was, does this apply to financial information like invoices and statements?
So the short answer is probably. And why I say probably is, please let's go back and remember that PoPI is focused solely on protecting personal information. So when it comes to financial information like invoices and statements, the question is whether or not there is any personal information contained within those documents. It is highly likely that there will be personal information. You wouldn't simply send an invoice or a statement to an anonymous person. So certainly there will be a name, there will likely be an email or a physical address or a postal address. So certainly there is going to be a degree of personal information within that document, and it will then certainly also apply the minute that happens. I hope that answers the question. I can go on just very, very briefly and say that approximately a year and a half ago, SARS put out a new regulation which very, very similarly to the Section 72 of PoPI deals with the kind of consent that you need to secure from SARS in order to store financial information or process financial information outside the borders of South Africa. So if we need to, I'm happy to sort of try and see whether or not I can get that information through to Kevin at First Distribution, who can then pass it on to you. But I think it is heartening to see that SARS and PoPI to some extent align around data sovereignty.
Okay, thanks, Theo. Another question that we have there is, does PoPI then allow for state information to be hosted outside the borders of South Africa?
Okay, so this is a hot topic in the public sector space at the moment. The reality is that PoPI is not aimed specifically at some form of state information. So let me just reiterate again that PoPI is only about personal information. So when you say, does PoPI apply to state information, it will apply to state information insofar as that information is personal information. So PoPI is applicable to absolutely everybody within South Africa. There will be exclusions in due course, but you can accept it that this is a general law that is applicable to everyone, including organs of state. But please, let's make sure that we understand that PoPI is narrow in its application, because it is only insofar as it deals with personal information that it is going to be pertinent.
Another question that we have relates to Office 365. And it says, okay, so for selling Office 365, would there also have to be a contract between the operator and the responsible party for PoPI, or is this more of a Microsoft concern?
It certainly is a Microsoft concern, but it's a great question because it's again about the general application of PoPI. And the reality is that if you're going to be selling Office 365, the contract under which Office 365 is sold and the service is regulated should be sufficient to constitute the contract that is contemplated under Section 21. I hope that answers the question. If it doesn't, feel free just to elaborate on your question. But in my mind, any one of the existing Microsoft contracts should sufficiently fulfill the purpose specified within Section 21 to constitute that written agreement required by PoPI.
Thanks, Theo. Okay, don't see any further questions there. So, Theo, thank you very much for joining us today and for the great information around that. And I hope that it really brought a lot of clarity to the issue of PoPI, and when it finally gets signed in, that we all then feel adequately armed with the information that we need to respond appropriately and responsibly. So. With that, before I end out, I just would like to remind everybody of the different interactions that we have with partners out there, and please invite you to join us and to like our page on Facebook, on LinkedIn, on Twitter. We have First Distribution profiles there and share a lot of this information via that. Myself personally, you can find me on LinkedIn, and you can also find me on Twitter at KevinDD. And I share a lot of information there around the cloud environments and the environment that we're all involved in, and pertinent issues around that as well. Lastly, just a final reminder about our stack. It always surprises me that I speak to a reseller and they'll say, well, we didn't realize you did product X or product Y. In fact, as Theo was here today, he saw all of the screens that we have on the wall, and so he didn't realize that we sold TVs, to which I corrected him and said that these are actually not TVs, but these are monitors, and we sell LG as well as Samsung monitors. So there's a host of products that we do, and please speak to any of the salespeople who will be able to help you if you want further information on that. I thank you for joining us. Thank again Theo for taking the time and the effort to share his this valuable information with us. And on behalf of the team at FD, thanks for signing in and listening to the webinar today. The next webinar will be on the 9th of May, and some great information that's coming up there regarding pricing. So please do join us. The invites to that will be out next week. And have a great long weekend, everybody. Thanks again for joining us. Cheers.